are the top 10 defenses to the crime of theft in Alabama? Let me go through them. The first is what we call a lack of intent. So, for example, Bob goes into Walmart and he's purchasing a variety of things. One of them is he has a roll of paper towels and he puts it on the bottom of his cart. He pays for everything, but he forgets the paper towels and walks out of the store. Is he guilty of the theft of those paper towels? He shouldn't be guilty because he did not have the intent to commit the crime. It's not to say that he might not be arrested, but his defense is, I didn't mean to, I forgot, it was a mistake, I had no intent. So lack of intent is the first. The second is what we call the rightful ownership or claim of right to the property. So let's say our friend goes back to Walmart some other occasion and a month before, he has bought himself a nice wristwatch. He's in Walmart, he's wearing the wristwatch. He had bought it from Walmart the month before. Loss prevention sees, they go, hey, that's one of our wristwatches. And old Officer Fife with the loss prevention arrests him. Well, he has a lawful ownership claim, say at trial or sometime before trial. He shows the receipt, says, go, hey, look, here's the receipt where I bought it. Oh, and you can roll those videotapes and see me purchasing it a week before. A claim of ownership or right will defeat a theft case. The third is what we call consent of the owner. Let's say Dave is going through a divorce, but Dave has bought his wife, Valerie, a car. But Dave, being Dave, has kept the title in his name. So he's the owner. He sees his neighbor, Ned. He says, Ned, you want this car? I'll sell it to you. Here, take it. You can pay me whenever you want. And he lets him take Valerie's car. Valerie finds out that her car is missing. She calls the police, reports it stolen. Poor Ned, he gets arrested by the cops. Does Ned have a defense? He does, because the actual owner, in this case, her husband, who had the title, gave consent to use the vehicle. And so the neighbor, Ned, is not guilty. We do see cases like this where there's some confusion over whose car it is and whether or not they had or didn't have permission. These things do happen, but that's a legitimate defense. The fourth is a mistake or a false accusation. So let's say we have Tom and Ted. They're two brothers. Maybe they're twins. They're very similar looking. And Tom has gone and stolen something, but people confuse them all the time. Ted gets arrested. Well, that mistaken identity or the false accusation against the brother who did nothing is, of course, a defense to a theft case. Fifth one, which we don't see very often, but is what's called entrapment. Well, what's entrapment? Entrapment means that law enforcement has created a situation where somebody who would not have otherwise committed, in this case, the theft, commits the crime because of and as a result of law enforcement creating the situation where they wouldn't have committed the crime otherwise. It's tricky. People get entrapment confused because, hey, if you're law enforcement and you want to put bait out and somebody willingly takes the bait and steals something, these trap cars and things like that, that's not entrapment. It's only entrapment if the person wouldn't have committed the crime but for what law enforcement did to create the situation. So somebody who just takes advantage of a situation that's been set forth, that's not entrapment. But we do occasionally see entrapment situations. Another defense is intoxication. Now, involuntary intoxication is what I'm talking about. Voluntary intoxication is not. So if Whiskey Pete drinks a bottle of whiskey, goes to Walmart and goes and steals a pack of Marlboros because he's drunk, that is not a defense. However, and I've had this happen with one of my clients, let's say that you're getting some sort of medical treatment and they give you some drugs and it makes you off your gourd. You don't know, for all you know, you're on Mars. And you just don't know what's going on. You're walking through a store, you're eating food and throwing the wrappers on the floor and stuffing stuff in your pants, and you just don't really know what's going on. Well, involuntary intoxication can be a defense. The reason it's a defense is if you don't have the intent to commit the crime of theft, you would not be guilty. Duress or coercion is the seventh defense. Not very common, but let's say some guy is saying, hey, if you don't go and steal that lawnmower for me, I'm going to punch out your daughter. The person does it because they don't want their daughter to get hurt. If that can be established, and if that's the truth, then they're being under duress or some sort of coercion to commit the crime can be a defense. Another defense, which is probably the most common, is just lack of sufficient evidence. Hey, the state doesn't have enough to establish beyond a reasonable doubt that somebody has committed a crime. And the jury or judge, whoever's looking at the facts, says, there's reasons to doubt, there's legitimate reasons where we don't believe beyond a reasonable doubt the person has committed a crime. That person would be entitled to a judgment of acquittal. Now, the ninth thing is not really a defense, but it's a mitigation. And that's when somebody returns the property. So let's say that, there's a party and some woman has a diamond necklace laying out, and one of her girlfriends is over. She goes to use the bathroom. She sees the diamond necklace in the bathroom and she steals it. A day or so later, she's like, what? She calls her up, says, hey, I'm so sorry, Jane. I'm bringing back your necklace. I couldn't resist at the time. Well, she's still guilty of the theft. That doesn't get her out of the theft. However, the prosecutor, maybe even the victim, maybe the judge, people will look at it a little bit differently because the person has tried to fix it, and they may get a lesser consequence as a result of their trying to correct their mistake. The last one is statute of limitations. Let's say it's the prom, and some girl steals another girl's high school graduation ring, has her initials on it, and the ring is stolen. The girl knows that her ring's been stolen. She knows who did it, but she is just not feeling like doing anything to her. She's going, I'll let bygones be bygones. As the years pass, she gets madder and madder. 50th reunion of the class, she's there. She sees the girl is wearing the rings. Old feelings boil up. And she goes to try to get her arrested for that theft 50 years ago. No, there is a limitations period. In other words, if you're going to pursue somebody for certain kinds of crimes, including theft, you have to do so within a reasonable period of time under the law. If you wait too long, it's blocked under what's called the statute of limitations. I hope that neither you nor anybody in your family is charged with a crime, but if you are and you want our help here at Siegel & Siegel, the phone number's below. I hope you enjoyed this video, found it to be educational. If you want to see more, just hit the subscribe button, and if you want to be really nice to us, give us the old thumbs up, the like button. Thank you for watching.